statement to come before the jury as evidence without the witness being sworn in or subject to cross-examination.
Your Honor, I would like to introduce the sworn affidavit from my wife.
Objection. Written statements are subject to the hearsay rule.
That's correct. Sustained.
My wife called you a big old jackbooted slug, didn't she?
Objection. Hearsay.
Overruled. Officer?
Yes, I believe so.
Oral and written statements made out of the court are hearsay, even if sworn to. This last question doesn't really go to the truth of the matter asserted, but rather to the declarant's state of mind. This may not be relevant, but that wasn't the objection. She is identified as a witness, and the judge chose to allow it.
Officer, didn't you say at the scene that I was getting a ticket for my attitude, whether I was speeding or not?
Hearsay.
Overruled. Officer, you may answer the question.
I may have said it to keep you from arguing.
Although this may fit the description of hearsay, it was a prior statement by the witness. Not every statement by a witness is admissible, but the exception is very broad. Any statement that is inconsistent with the witness's testimony is admissible. Any statement dealing with fabrication or motive, as is the case here, is admissible. A statement by a witness identifying a person is also admissible. Prior consistent statements made by a witness are generally not admissible unless prior inconsistent statements are also admitted.
No more questions.
Any redirect questions, Ms. Prosecutor?
Just a couple, thank you, Your Honor. Officer Best, did Mr. Law say anything about whether he was speeding?
Well, at first he denied it, and then...
Objection. Hearsay.
Admission by party opponent, Your Honor.
Overruled. You may continue your answer.
Then he said, speeding or not, I'll see you in court, jerk.
Admissions made by a party are any statements that they made out of court, regardless of whether the party has testified or will testify. Admissions made by a party also include statements adopted by a party. Adoption is when a statement is made in a witness's presence in a way in which the witness appears to agree with the statement. This exception makes confessions admissible.
Officer Best, you had an observer with you from the local high school on this date.
Yes, his name was David Young. He was 18 at the time.
Did he say anything when you first put the radar on Mr. Law's car?
Yes. He yelled, well, look at that guy. He's flying down the road.
Objection. Hearsay.
Present sense impression, Your Honor.
Overruled.
When you returned to the vehicle, did he say anything?
Yes. He was very flushed and worked up at the confrontation in Mr. Law's vehicle, and he said...
Objection. Hearsay.
Excited utterance, Your Honor.
Overruled.
He said, that guy was so rude and you were so nice. Now I've changed my mind. I could never be a cop. I would have shot him.
Those were two examples of exceptions to the hearsay rule: present sense impression and excited utterance. A statement describing or explaining an event as it happened or as it was perceived or immediately thereafter is admissible as a present sense impression. An example is the young man pointing out the speeding vehicle as he sees it speed by. Present sense impressions are admissible even though they are hearsay. An excited utterance is a statement, 1, related to a startling event or condition, 2, made while the declarant is under the stress of excitement, and 3, caused by the event. These statements are also hearsay, but admissible as excited utterances. The declarant must be excited or stressed. The 18-year-old riding along qualified. The officer might not. Both of these exceptions to the hearsay rule are created because something about the statement argues that it would not have been made if it were not true. There are many other exceptions to hearsay, including public records, records of regularly conducted activity, family records, and statements made for medical treatment. Each exception is contained in Rules 803 and 804. Each must be established by proper predicate of proof before the statement is admissible.
No further questions, Your Honor.
Mr. Law, any more questions?
No.
Officer Best, you're excused. Any further witnesses for the state?
No, Your Honor. The state rests.
Mr. Law, do you have a witness?
Your Honor, my wife has the privilege not to testify, right?
Ladies and gentlemen of the jury, I'm going to ask you to step out.
There are issues that need to be addressed by the court that the jury shouldn't hear. For example, the invocation of privileges. Other examples are protracted objections or offers of proof, which are a record of items that the court has held are not admissible. A spouse has a right to refuse to testify in a criminal case against his or her spouse unless the defendant is accused of a crime against the spouse or member of the household. Communications between spouses is also privileged. Either spouse may invoke this privilege.
My wife will not testify.
Ordinarily, your wife would have to invoke the privilege, but since the prosecutor has not called her, all you have to do is not call her.
Also, I do not want to testify. I invoke my Fifth Amendment rights.
Thank you, Mr. Law. You have the absolute right to do that. And the jury will be instructed to not consider the fact that you have not testified in any way. Is there anything else?
Yes. I have a letter here from this officer's captain reprimanding him for being rude to a citizen back in 1997.
Objection. This document has not been authenticated and is not relevant under Rule 404B. And finally, it is hearsay.
Sustained. Anything else?
No.
Recall the jury.
The two rules referred to are both important. Any document or item must be authenticated by a witness or affidavit. There must be sworn testimony or admissible hearsay in the form of an affidavit establishing that the writing or item in evidence is what it is purported to be. The letter was not authenticated without testimony. Rule 404B is important because, except in limited circumstances, proof of prior conduct of a person is not relevant to prove that he acted in the same way in the instance at trial. In other words, proof that the officer acted rudely once in the past is not relevant to whether he acted rudely in this instance. It can become admissible only if it is introduced to show motives of the actors, plans the actors created, a lack of mistake in committing the acts, or similar grounds listed in the rule. Applying this rule depends on determining why the evidence is being offered. Generally, previous bad acts are introduced to show that if the actor did this once, he is more likely to have done the same thing in the instance at issue in trial. Such testimony or evidence is declared by the rules of evidence as irrelevant. Now we are going to closing arguments. Remember that in actual trials, you must read the jury instructions to the jury before an argument.
Are both of you ready for closing argument?
Yes, Your Honor.
Yes, Your Honor.
The prosecutor goes both first and last, but both sides have equal time.
May it please the court, Mr. Law. Ladies and gentlemen, without speeding laws, we are all at risk. For our own protection and for the protection of our children, we have limits. Mr. Law broke those limits, and Officer Best caught him. That made Mr. Law angry, but it doesn't make him not guilty. Who was rude to whom doesn't matter. David Young said it best. Look at that guy flying down the road. Now, if Mr. Law wasn't speeding, he would have called his wife to the stand.
Objection. She had a privilege not to testify.
Sustained. The jury is instructed to disregard that statement.
The parties cannot comment on witnesses who do not testify due to the invocation of privilege.
Officer Best did his job. He caught the speeder. I did my job. I prosecuted the speeder. Now you do your job and find him guilty. Thank you.
Mr. Law, you may close.
Ladies and gentlemen of the jury, if I was guilty, why did this prosecutor offer me defensive driving?
Objection. That was not in testimony and is not relevant under Rule 410.
Sustained. The jury is instructed to disregard that statement.
Plea bargain offers, offers to compromise, and subsequent remedial measures are all specifically prohibited.
This systematic harassment of good citizens like yourselves in order to line the greedy pockets of our city's government has to stop. The question you want to ask yourself is, do you trust these bureaucrats? Well, do ya? Not guilty. Power to the people.
We waive further argument.
Ladies and gentlemen of the jury, you may retire to consider your verdict.
There are a number of rules and exceptions we didn't cover here, but there is no substitute for reading the rules of evidence. Also, as a trial judge, you should listen carefully to objections and invite response if you're not sure. But, equally important, make a firm decision and follow it. You are the judge. Don't be worried if someone stands up and says, "I object."